session. The Honorable Yes Nicole is presiding.
Good afternoon, everyone. Thank you. Please be seated.
Common People versus Joshua Zuazo, case number 2024-291950 FC.
John Pietrofesa and Andrew McGarrett on behalf of the people.
Good afternoon, Your Honor. Michael McCarthy, P30169, appearing on behalf of and with Joshua Zuazo. Mr. Zuazo is standing next to me and to my left at the table.
All right, sir, tell me your name.
Joshua Zuazo.
Okay, we're ready for closings.
Yes, Your Honor.
And we've gone through instructions, and everyone's satisfied with the packet that's
Yes,
sitting
Your
there
Honor.
on
The attorneys
bench.
thank your staff for helping during the lunchtime break.
Oh, they'll appreciate that.
And I
They were running
joined
around. Yeah. Okay.
That is right.
Thank you. I appreciate that. So I believe all your jurors are, Mr. Zuazo's jurors are back, so we will bring them in, get right into it, and then instruct them.
All right, for the jury, please.
Please be seated.
Please the court. Counsel. Good afternoon. All the evidence, testimony, text messages are now before you. The case is going to soon be yours to decide when Judge Polis gives you the law to take back there. You'll have a written copy to read through. I was watching something just the other day, actually on YouTube, and a guy was talking about perception versus perspective. And he was talking about how we go through life. Normally, we're looking at things as you go through it through your own perception. You know, you're seeing the events around you, the people around you. But there's also perspective, which is how are those folks looking at you? And that's stepping outside yourself and looking back. And I really thought about that coming into today's closing argument, because my perception doesn't matter. If it was my perception that mattered, I think I don't even need to make a closing argument. But that isn't what matters. What matters is your perception of the case, and that I don't know. So what we're going to talk about are things I think are important when you go forward, but it's impossible, and I'm not going to, and there's no way to do in 20, 30 minutes everything that we've discussed. It's impossible. We all have faith that you took notes. We all have faith that you paid attention. So go back and rely on that when you go forward. Now, we talked from the start about what this case is about and what this case isn't about. And from the start in jury selection, what we said is this is first-degree murder, but it's not first-degree premeditated murder. And we discussed that from the beginning. And Judge Polis will instruct you on what this is, which is first-degree felony murder. And that means, and the people have never said anything different, nor has law enforcement, that this was an intentional killing when they showed up on the doorstep on October 11th of 2024. And the judge will instruct you on the law, which is now before all the attorneys. And I'm not going to go through, there's a stack that Judge Polis will read to you, which there's no point going through it twice. But what you have to focus on regarding first-degree felony murder was that the defendants intended to commit a larceny. And that during that larceny, They caused the death of Mr. Murray by either intending to kill him or intending to do great bodily harm to him or creating a high risk that death or bodily harm could occur. And then the judge is going to instruct you about aiding and abetting, which we also talked about. And it'll say anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. Now, I believe the facts have shown there were 3 people in that basement. Okay, and Mr. Murray is not able to talk about what happened in that basement. But I think the facts have shown throughout this, and I think the text messages tied everything in together even more, that from before, during, and after, these defendants had planned to commit a larceny at Mr. Murray's house. And each of them played different roles and different parts, but each of those parts were going together for that same mission, for lack of a better term. And you'll hear and you've heard that Defendant Hernandez started a year before with his contact with Mr. Murray. He had personal contact at his pawn shop in Hamtramck a year before, October of 2023, where he was engaged in making pawns with Mr. Murray's shop. And then you heard, and you have the records, that in February of 2024, Mr. Hernandez appears again. And when he appears again, not only does he take some things out of pawn, but he asks to speak with Mr. Murray face to face. And Mr. Murray came over, shook his hand, looked him in the eye, and talked to the co-defendant Hernandez. And the other interesting part of that, because there are little bits that maybe don't seem that important, and maybe they're not, that's for you to decide. But what is Hernandez in there looking at? He's in there looking at Rolexes. What does Mr. Murray wear? He wears a Rolex. What does Mr. Murray have on him? He has jewelry. After that day, and as things went forward, you've seen the text messages, you've heard the connection between the 2 co-defendants, and it's a substantial connection. These are not Facebook friends who never hang out. These are not high school friends that only see each other at reunions once every 5 years. These 2 have had a close connection, and it continued throughout this time. And I think there's proof of that through witnesses and through the text messages. You heard from Ms. Diaz when she testified how the defendant, Zuazo, was going to be in the wedding in September of 2024. You heard from Ms. Diaz that she knows him by the nickname of Yogi. You heard from Ms. Diaz that she identifies the defendant that morning of October 11th when he's in the Lowe's with co-defendant Hernandez. You've heard as the testimony, the text, everything else is played out. You have lots of videos to show that they put their plan in place to physically start making it happen probably about 20 days before the murder. And you hear that through the text and through their actions. You start seeing the text that you now have today about we need a car between Hernandez and this defendant. And they go back and forth about getting a car. Why do they need a car? Well, they need a car because they want to get away with it, first of all. And they're going to do that by disguising the vehicle that they drive and then disguising themselves. They're going to disguise that vehicle after they steal it, and you've heard testimony from the victim of that theft about his car being left out and it gone, which coincides exactly with the text that you have now. You also saw a text that indicate that you need to disguise it with DTE materials. And you saw not just Hernandez walking in on video into that store to order up those signs for the sign of the car, but you saw this defendant text messaging his buddy, whether it's a male or female buddy, I don't know, but the buddy to get DTE products to disguise themselves. They go a step further, and that's to get rid of the plate, which was a very distinguished plate on the back of that truck, that Poco plate. and they got a DTE plate stolen from a DTE vehicle to make it even more unlikely that they're going to get caught if that vehicle is identified or if it shows up on a flock camera. Like everyone here now knows, is taking pictures of a lot of plates. Well, it would have come back with a DTE plate. And that disguise, as you heard, was so effective on October 11th that even Miss Niehaus, as she's walking her dog, and she said, my attention's drawn to that vehicle, first by the sound of it, but then it just seemed to be slow rolling through the neighborhood. And she said, I finally looked up and I saw it was marked as DTE. And I said, oh, it's DTE coming through to do something. And she was no longer concerned about the vehicle. Well, that's what these defendants intended. Now, you have the videos, you have the purchases at Home Depot, at Lowe's. They were getting the things that they were planning to use when they were going to get into Mr. and Mrs. Murray's house. They wanted duct tape, they wanted zip ties, they were disguising themselves as workers with different things that they purchased also at those stores. They were ready, but there was one thing that they could not buy at any hardware store for that day. And that was the will to do what was necessary. That will to go into that house and do what was necessary, you can't purchase that at a store. That came from in here. They were ready to go. And on that October 10th, when they drove there, it was this time of year, it is dark. You've got all the text before and after. And as they drive there, 40-minute, 45-minute drive, no one gets out of the vehicle. No one talks themselves out of doing what they're about to do. They're ready. They're planning, and as you saw through the text, Mr. Hernandez wants to buy a house. Mr. Zuazo is talking about needing a big score. And they had this impression that inside that house was going to be their big score. As they get to the house, and as you've heard, they approach the house, Mr. Hernandez in front, posing as DTE workers with Mr. Zuazo right behind him. And that does not, is captured on Ring video. There's the knock on the door, which catches everybody's attention inside. Mrs. Murray said she gets it on her Ring video from her phone, and Sam is already downstairs and heads towards the door. She's upstairs, and she's paying attention. So Sam opens the door. Defendant Hernandez with the co-defendant right behind them. They're trying to talk their way into the house. Mrs. Murray says, it's a little late to be doing a gas check. And then she says, Sam, do you have your gun on you? And she said, I said it loud so it could be heard. Mr. Murray doesn't want to let him in, isn't going to let him in, and doesn't let him in. Mr. Hernandez says, we'll be back tomorrow. So they leave that night, and then they have a 40-minute drive back to where they came from. Did anybody decide not to go forward with this the next day? No, there was a different type of discussion. And there's unanswered questions that we talked about in jury selection. Some of those unanswered questions don't matter, okay? It only matters if it goes to what we need to prove in these elements. One of the unanswered questions is, why didn't they force their way in? Okay, well, they didn't force their way in is what happened. But if you remember the positioning, Sam is downstairs. He is not a small man. He's 6 foot tall. He's 300 pounds. Hernandez is in the doorway, okay? And it's been told that he's armed. Could they have gotten to Sam before he pulled his gun? Could they gotten to Sam before he backed up and pulled his gun? I don't know. But what I do know is if they had come in that house, they could not have gotten to Mrs. Murray upstairs on that balcony before she called 911. There was no way they were getting to her before that call was placed. So they leave to regroup, and they regroup. They don't cancel it. They don't say there's Ring cameras, I'm not going to do it. They don't say the guy is 6 foot and 300 pounds, he may be a problem. No, instead they revise the plan. The plan doesn't get canceled. How do they revise the plan? Well, now they go first thing in the morning to Lowe's to get the 18-inch zip ties. So they're upping what they expect they're going to need to subdue Mr. Murray. The duct tape no longer is enough. They need zip ties, and those are the same length zip ties that the detectives described that is in the bloody scene in the basement. They have the drive back. No one gets out of the car. They both arrive. And as they arrive this time, when they're at the front door, which is captured on the Ring video, they're able to trick Mr. Murray into opening that door. Mr. Murray goes to the door, as you've heard. He lets them in, as you've heard, and Mrs. Murray is there watching this. She says it sounded like Mr. Hernandez was going to go outside, but he didn't. And you also heard that defendant Zuazo starts lingering around where the dryer is, which is a gas dryer. So they start going downstairs. And what's important to note is the little pieces of things, which you have. I'm sure you have. So Sam goes down the stairs first. Who's following Sam? This defendant, not Hernandez. The first one to go downstairs behind Sam is this defendant. The first defendant who's going to encounter Mr. Murray is this defendant. And Hernandez goes down behind him. The door is closed. And you know some of what happens next. We don't know all of what happens next because Mr. Murray isn't here to tell us. What you hear next is defendant Hernandez comes up and he immediately confronts Mrs. Murray, who's right there. She doesn't hear anything for that 10 or 15 minutes. No screams, no shouts, no commotion. But she sees Hernandez. And he starts with, where's the safe, where's the money, where's the jewelry? And obviously, that conversation triggers the realization that these are not DTE workers, that this is a problem. And she answers immediately, we don't have a safe, the money's in the purse, there's no real jewelry here, it's upstairs. And you hear at that point in time, defendant Zuazo comes upstairs. And when he comes upstairs, Sam isn't with him. And when Mrs. Murray sees Zuazo, she asks, where's my husband? And she's asking, where's my husband? And he comes up and hears that. Hernandez doesn't say anything in response to that. Zuazo does. And what he chooses to say is, he's sleeping. And at that point, she sees the blood on this defendant's chest. And she starts screaming. Hernandez immediately punches her on the left side of the face, as you've seen the photos and as you've heard in testimony. And what else does Mrs. Murray say that is important? And as you look back through everything, all that we ever want is for you to use your common sense about what makes sense, what doesn't make sense. And what makes sense is exactly what she says. She says she sees his whole face because the mask is no longer in position. And what makes sense about that, because he's tried to disguise his face with the mask, both on the 10th and on the 11th. But why it's not in place anymore is because he had just been in a struggle with Mr. Murray down in the basement. And that mask had been moved and dislodged during that life and death struggle. And that life and death struggle was just Mr. Murray's life and death. These defendants were never concerned about their life or death. And if you heard, the only blood, there's DNA from the defendants. There's never any blood from the defendants. The only blood that you see, and there's a lot, is from Mr. Murray. Now, she sees his face, she describes him to the police officer, she describes the facial hair, and you heard the officer yesterday testify when he was arrested, he had facial hair. And then you've seen the Lowe's video from that morning where the defendant is there with Mr. Hernandez with facial hair, with the bucket hat that's later found. So does that end it? Does the defendant head for the door? Does he say, I'm getting out of here? No. Where does he head? He heads upstairs to continue the mission, which is to find the jewels or this treasure that doesn't exist. So he goes upstairs, and you heard that when he goes upstairs, those rooms are ransacked. You saw those rooms are ransacked. The costume jewelry is every place. And you also heard Mrs. Murray testify that Hernandez never went upstairs. Only this defendant went upstairs. And what else is upstairs? The victim's blood on that swipe on the wall. Because there's so much blood that was downstairs, the defendant got the blood on him and left it upstairs. As that's going on, Mr. Hernandez is still looking for items, trying to get into the purse, trying to take the car keys, taking the cell phone, taking all these things. And the gun is missing. Gun's never been found. Last time it was seen, it was going downstairs with Mr. Murray. That gun is missing. Mrs. Murray tells you that she's bound up by the duct tape. You saw how Sam is bound up in the basement. He's not just bound up with duct tape, he's bound up with the zip ties that they had just purchased. And then you hear this defendant returns from upstairs, wanting to go. We need to go. But what does he want to do? This defendant. He wants to put Mrs. Murray in the closet. He wants to put her in the closet before they go. And he starts trying to do it with Hernandez, but she's duct taped in a position that she can't be moved into the closet. So as much as they tried to even do more, they weren't able to. So they depart and flee. It's not over, because they got to try to get away with the little that actual value that they took. The only thing of value that they took that day was Mr. Murray's life. That's the only thing of value that was taken. The rest was junk. What do they got to do? They got to go get that truck down in Detroit, and you saw the text messages where it sounds like it's pre-planned. You hear that they set that truck on fire to burn its contents, burn any DNA that's inside the truck, and then it's time to get out of there. Hernandez gets home. You've heard the testimony that he quickly packs up that Jeep, packs up his wife, packs up her child, and they start headed down south. Now, when they get down south, they don't have much of a drive before law enforcement is quickly on them. Law enforcement finds a lot of objects of value that are later processed. You've heard about all those objects, which include the 13 size shoe, which is Mr. Hernandez, and in fact, the video, you can clearly see he's wearing those Nikes in one of those videos. You also have the brown boots that are size 11 that are not able to fit Mr. Hernandez's foot. And you also heard today that the defendant's shoe size is 10 and a half. And I don't know about anybody else who buys shoes, but my shoe size range it's a large range between what brand you buy. 10 and a half, 11, 10, they all can fit the same foot, as everyone knows out of their own common sense. So they find a bucket hat that belongs and is seen on the defendant. You also find the jewelry items that were taken by the defendant. All of those things, plus more, are found in that vehicle. Now, at that point in time, the attention of the sheriff's office has quickly been focused on Mr. Hernandez and this defendant also. You heard from Mr. Broad, who calls into the sheriff's office and says, I know that guy. He testified yesterday. I know that guy. I worked with that guy. He identifies him from the video. He identifies the clothing from the video, and he identifies those boots being consistent with the type of boots that are used at their scene. So then you hear more gruesome details today from the medical examiner about the manner that Mr. Murray was killed. Those photos show a lot of light about what happened in that basement. It was a brutal beating, a multiple hit beating, a beating that could certainly have occurred with two people, regardless of their size, But when we talked about the Rolex, it's important when I think about things about how did it physically transpire. He has 2 strikes to the back of his head from a blunt object, consistent with a gun, consistent with a lot of other objects that could cause that type of injury. Okay, so Sam goes down. You know, they ask for the safe, maybe. He's not giving an answer, maybe. He says, I don't have anything, maybe. But you know that conversation occurs. It occurs upstairs, and they don't like that answer either. So Sam is struck and he's bleeding. But he's not quitting. You heard Mrs. Murray talk about he's a strong man. You've heard he's a big man. And he's not unconscious, because if he's unconscious, how could I say that? I wasn't there. Well, because it doesn't make sense with the rest of the facts in the case. If he's unconscious, you don't have to bind him up like that. You don't have to duct tape him. You don't have to duct tape his mouth. You don't have to zip tie him. This is a struggle at a minimum with Mr. Murray and the 2 defendants. And what else do you hear? That as much as Mr. Hernandez loves Rolexes, as much as the only thing of financial value in that whole scene that day was probably that Rolex, what happens during this struggle? This struggle occurs to the point where he's duct taped and zip tied where you can't even get to the Rolex. If he was unconscious, if he wasn't there, the first thing that comes off is the Rolex. Maybe they try to get the ring off, but the thing of value is that Rolex. Can't even get to it, but they don't care because they're in a struggle with him. Now, that beating had many injuries to Mr. Murray that you've heard about. And we talked to the medical examiner about the compression to the throat and about if someone's struggling to break that compression, whether it's a knee, a hand, a foot, you know, it would reset your clock. You know, if someone's trying to choke you, you knock it away, it resets the clock. Keep doing it. So I believe it's taking 2 people to try to restrain Mr. Murray. And that fact is borne out by the fact that you have blood on both defendants. There's no version where any defendant left that basement before that violence occurred. Impossible, because you're not getting blood on your boots, you're not getting blood on your Nikes, you're not getting blood on your shirt. Both shirts. Because the t-shirt Mr. Hernandez has tested also has the DNA on the blood. So that battle is going on down there. And, you know, I try to think about it like just normal life, okay? I have a brother 4 years younger, okay? So growing up as kids, when we would roughhouse, wrestle, things like that, there was a point in time where I could get both of his wrists in one hand. And I could put him down with one hand and hold him in place. And then I had one hand free. That stopped when we were about 12 years old. I could no longer control him with one hand. There was no way one person was controlling Mr. Murray all by themselves. To both tie him up, keep him in a position, do all that, that doesn't seem to me to be reasonable. I think Mr. McCarthy is going to say a few things at this point. Give him your direct, full attention like you have throughout this trial, and then I'll have a few minutes afterwards to address what he says.
Thank you. Mr. McCarthy.
Thank you. Good afternoon. I want to thank you, first of all, for paying attention during the course of this trial. I talked about that in my opening statement. I think I may have touched on it a little bit while we were conducting the jury selection on Monday, but I did for sure talk about it in opening statement about how important it is to pay attention so that the 12 of you that are ultimately chosen to go back into the jury room and deliberate will have all the information you need in order to actively participate in those discussions. And I'm convinced that all 13 of you here present today, this afternoon, have fulfilled the solemn obligation of your oath. And on behalf of Joshua Zuazo, I thank you for having done so. And now it is, in a short time, going to be your opportunity as well as your obligation to do the one thing that brings us all together here, to discuss the one thing that brought us all together here this entire week, and that is to determine what the facts are. As I said in my opening, I'll repeat again, that a trial is a search for the truth, and you all are the truth finders. You are the people who are going to make a determination based upon the evidence presented during this trial of what that truth actually is. And then ultimately the practical reality of those decisions that you make in coming together and determining the truth is going to be whether you find that there's been evidence presented to the high standard of proof beyond a reasonable doubt to convince you that Mr. Zuazo is guilty of any one of these 3 crimes with which he is charged and for which he has undergone a trial before yourselves. First-degree felony murder, unlawful imprisonment of Hussein Murray, and unlawful imprisonment of Linda Murray. One of the things that impressed me about the evidence that we have heard, and one of the things that I told you in the very beginning of the trial, is that this is about identification. And I understand Mr. Pietrofesa's argument, and he is attempting to convince you beyond a reasonable doubt that that second person who's there with Carlos Hernandez in the Murray home on the 10th day of October in the evening, and on the following morning, the 11th of October of last year, is Mr. Zuazo. But there's quite a difference between what you're able to perceive in all of the videos that have been shown to you, which, are exhibits, and you are all welcome, as Judge Polis will tell you, if any exhibits that you want to see, you're going to be able to see again and go through them. And I encourage you to do that very thing, especially from that Friday when it's daylight and you can see. And take a good look at who that second person is. And ask yourself, is that really proof beyond a reasonable doubt that it's Joshua Zuazo, or is it somebody else? Because when it comes to identification, besides what you can see just in little clips from those videos, comes from Mrs. Murray and Kelly Broad. He testified yesterday. I believe it was yesterday. It might have been Wednesday. But whichever day it was, he testified during the trial, and he is the person who used to be Mr. Zuazo's supervisor, 2 levels up from him, but some sort of a boss at the St. Mary Cement Company. And I don't know about you, but I had a little difficulty following what he was saying. I know he was here for a reason. First of all, he was subpoenaed, so he's obligated to be here. But he was here to make sure that who he says had threatened him when he fired him got convicted in this crime. He says that he knows it's Mr. Zuazo because in the video he is wearing Wolverine steel-toed boots given to him by St. Mary Cement Company. And he's wearing safety glasses. Prescription, he says, given to Mr. Zuazo by St. Mary Cement Company. So the thing that I ask you to do is scrutinize what he had to say. And the reason I say that is because in the instruction that the judge is going to give to you a second time, she's already given this to you once before the evidence presentation began, is about witnesses and sizing up the witnesses and making a determination about who do you believe. And one of those things that she's going to repeat is words to this effect about, does the witness try to actually answer the questions, or does the witness argue with the lawyer? And I would add this: does the witness ask the question presented? Now, I've been doing this job of representing people in trial and conducting litigation in civil matters as well as criminal matters for 45 years. And so I consider myself pretty capable of keeping people on point and getting them to answer the question that I put before him. Ask yourself in your memory how many times I had to repeat a question and ask him to answer the question that I put to him. Was he honestly trying to answer the lawyer's questions, or was he arguing with the lawyer? And this is a huge piece of evidence that is presented specifically to fill in some gaps about who that second person is and make it be Joshua Zuazo. I submit to you that Kelly Broad was not honestly trying to answer the questions. He was here with an agenda. He claims that Mr. Zuazo threatened his life, but he never reported that to the police. And he says that he can tell that these are Wolverine boots. The fact is, when I asked him the question, I said, well, all you can see is down at the bottom. The person who's wearing those shoes is wearing long pants. How can you tell all these things? Well, he just knows that that's true. Well, if that's so true, and the people's theory about Mr. Zuazo's presence at that place, the home of the Murrays, then how come there aren't some brown Wolverine steel-toed boots in Mr. Zuazo's house when it is subjected to a thorough search? Why aren't those steel-toed Wolverine boots that Mr. Broad is so certain were present in that video in the Jeep that is racing from Michigan to Texas and is stopped in Louisiana? Those are Timberline boots. And there's no evidence that those are Mr. Zuazo's boots. There's no DNA in those boots that says it is Joshua Zuazo's DNA. There is DNA that says that the blood on top of one of those two boots is Mr. Murray's. No question about that. Who is to say, what evidence is there that is reliable that it's Joshua Zuazo whose feet were in that boot? Where is this shirt that Mr. Broad claims he recognizes as a St. Mary cement shirt or covering, whatever it was, this yellow-looking thing that you can see in the video? How do you know that that's from St. Mary? When I told him that there was this, in the video that I watched of him, on his shirt he had a name tag, or the company name is what he said. I couldn't see it very clearly in the video I watched. But he explained, yeah, he says that's St. Mary Cement Company says that on this green patch. And then he adds in, well, of course, those can be easily removed. Okay, well, there wasn't one of those on that shirt, and he claims there's this thing on the shirt, though, that says fire repellent. I think was the two words, FP or FR, and so there'd be some kind of safety shirt that the St. Mary people have. He claims he can see that in that video. I encourage you to take a good look at that and see whether that's what you see. Or is what you see a name tag holder, a clip of some sort, something like all of you have for your jury badges, up there on that shirt that this second person was wearing, and not some initials from the St. Mary Cement Company, but just the clip to hold on to the fake DTE Energy tag. Question of fact for you to decide. Then we have the fact that the other person making an identification of Mr. Zuazo is Mrs. Murray. She's a compelling witness. And who among us would ever want to be in her shoes? And this was without question, and she honestly answered this for me when I cross-examined her a couple of days ago. The terrible, traumatic situation, an experience that she's never had before, of course, and is living with to this day and cannot get it out of her mind and thinks about it all the time and certainly has it on the forefront of her mind because she had to come here and give this testimony. And she's here present and has been throughout the time that has passed since the time she gave her testimony. And so one of the other instructions you're going to get is that you cannot let sympathy or bias or any human emotion enter into your decision making. And I ask you to think about the two witnesses from the Oakland County Sheriff's Department who testified yesterday, Deputy Hagelin and Deputy Wigman, about the description of the second individual that Mrs. Murray gave when they conducted interviews with her. Deputy Hagelin was not the first person who saw her. That was Deputy Copeland, who was the first man on the scene. And his interaction with her was rather brief, and he got her out of harm's way, or at least where he hoped it was going to be out of harm's way, so that he could summon more deputies, and he didn't have much interaction with her. Deputy Hagelin took her and put her into a vehicle, a police vehicle, for her own safety and to give her an opportunity to be sitting down and out of all of the activity that was going on in her home and talk to her. And what she told him was that it was a person of average size. Black male, but a person of average size. Didn't give any specifics. That was the same thing that she said to Detective Wigman, who saw her more often. He saw her in the hospital emergency room on the 11th of October, and then he said 2 or 3 or 4 other meetings after she was discharged from the hospital that day in the following days. And those meetings were conducted in the home of her son. But never once did she give a description to say that Zuazo, or the second person rather, who she has now identified as Mr. Zuazo, was 6 foot tall. It was always a black male of average size. Now, she was specific in her description to Detective Wigman about who is, we know, Mr. Hernandez. Very tall and fat, very fat. One of the pieces of evidence that's been admitted during the course of this trial is that when Mr. Hernandez was racing away from Michigan to Texas, where he thought he could hide out until he was stopped by the Cato Parish Sheriff's Department in Louisiana, Shreveport, he got taken into custody, and as is the custom or the protocol for putting a person into custody and incarcerating him, they take some statistics or information regarding that individual, and they have him booked in at 6'6" and 450 pounds. Now, going to the basement of the home of the Murrays on the morning of October the 11th of last year, there was a person weighing 450 pounds who was very capable of squeezing the life out of Hussein Murray by using his foot, using his knee, using his hand, because no matter how you press down, what part of your body, when you're that big, you press down with your knee, your foot, your hand, you're going to have 450 pounds backing you up. And that is a tremendous amount of weight. So when we have this compression, because that's the cause of the death, is this neck compression, not only does Mr. Murray have a fractured jaw, but he has his hyoid bone right up here in the top of his neck. And that is an essential thing you need in order to be able to stay alive. His gets fractured not in one place, but in 2 spots. It's crushed by somebody's sustained effort to do that. Why is that going on? Who is intent about doing that? Well, I would suggest to you that the person who's text messaging back and forth between himself and his new bride, Mr. Hernandez, talking about getting a house, hope we have a good score, she's helping him plot this crime that he's committing. And remember, it isn't just a house, our house. Starting out, this young married couple with this dream of having a house will go out and commit a crime that includes a murder in order to have one. But also, not just any house. Look at those text messages that were admitted, I think, as exhibit number 22, but they're all in there. A house with a nice yard. I don't know why the plotter, the planner, who's up to her eyeballs in this thing, Amanda Diaz Hernandez, the new bride, is not sitting over here at the defense table. But that's not my decision to make. But if anybody is involved in a conspiracy to commit this robbery, this stealing of property from a person who they know to be, they being Hernandez and his wife, to be a man of property because he owns a jewelry store and he owns a pawn shop in Hamtramck, and then, you know, he's out there scoping out the house, and you can all see, as bad as the pictures are, given the circumstances under which they were taken, the home, the Murray home, on the 10th day of October was a beautiful place where the upstairs wasn't ransacked. And you can tell they had very nice furnishings and everything was properly appointed. And it was a big house with not one but two stairways. So they've got this man targeted. And you heard Mr. Pietrofesa say that Hernandez was over in that pawn shop asking to talk to and meet Mr. Murray. Why is he doing all that? You got any evidence presented to you about Joshua Zuazo pawning stuff at this place? Going in, asking to talk to the owner? No. And who is the man in the forefront all the time? It's Hernandez. He's the guy right up there to the front door. He's the guy with the clipboard. And when the police come and they do the search at that house in Lincoln Park that mother, Danielle Diaz, who had the bad leg, was here yesterday with a giant chip on her shoulder, a little difficult to talk to also. When they come and they do that search, among other things, they find the DTE Energy cutouts designed by, apparently, one of the two of them, or maybe both of them, worked on it together, a kind of a joint project of the young married couple, so they can have their dream house. And that's not in Mr. Zuazo's house. It got searched thoroughly. You don't see one piece of evidence in this trial that came from Mr. Zuazo's house. But there's a lot that came from Hernandez's house. How about that white shirt in the back seat of the Jeep, or the back of the Jeep, that's got Mr. Murray's blood on it? Now, you know, I made a point, and I'm not trying to make fun of somebody because they're overweight or big. I mean, this is only because it's an essential fact in this case. It's a 6X, and his DNA, Hernandez, is in the collar, you know, of the shirt. And if it's his shirt, then that just makes perfectly good sense. But the blood, that is Mr. Murray's. There are no clothing items. There is no evidence that connects Mr. Zuazo to Mr. Murray's blood, period. There are shoes, size 13, in the back seat, or in the back of that Jeep, that are taken into custody by the Cato Parish Sheriff's Department and then handed over to the Oakland County, Michigan Sheriff's Office. And those are analyzed. We had the testimony from the DNA witness here, I believe it was yesterday, Ms. Ramirez. And it's up in the octillions, for 1 in so many octillion, that it's Mr. Murray's blood on Mr. Hernandez's shoe. There's the black gloves. There's black gloves seen by Mr. Hernandez, or on Mr. Hernandez during the crime. And what do we have in the back seat? His DNA inside those black gloves. No question he was there. No question that this horrible crime was committed and that he is responsible for it. And this whole idea of all this was supposed to be as a robbery. Well, I can't tell you what's in somebody's mind any more than Mr. Pietrofesa can on the day that this happened, this horrible, tragic, criminal thing occurred. I don't know what Mr. Hernandez is planning on doing. But I do know that, while there's no doubt, no reasonable doubt, that he is responsible for all of those things that happened, there is no such evidence beyond a reasonable doubt that it's Mr. Zuazo. Let's look at one other video. It's at the Lowe's. It's at 9:30 in the morning, and it's down in Allen Park, I believe. And that video shows Mr. Hernandez walking around inside the store, and then he's buying items, and then he pays for those items. There's another person with him. The people allege and argue that it is Mr. Zuazo wearing this bucket hat. And the bucket hat gets found in the back seat of this Jeep. Now, I'm not much of a hat wearer. I have a couple of baseball hats, but that's about it. I understand, though, that there are people that like that type of style of hat, and I guess in sunlight or sunshine, warm days, maybe it's a good thing to have. Keep your face from being burned up or your neck. Well, whatever the reason somebody's wearing it, if it was Mr. Zuazo, you would think that there would be some DNA on that hat, on the inside of that hat, for this person who's wearing it. If, in fact, that's who it was. We don't have that in evidence. We don't know whose hat that was. We don't know who was wearing it. We don't even know, really, whether the person who was wearing that hat left that hat in the back of the Jeep. But we have one other thing, and that is a number of items taken from the Murray home, stolen. Any of those at Mr. Zuazo's house? Any item from the robbery, the larceny rather, that took place as the predicate felony to charge first-degree felony murder in the hands of or anywhere near where Mr. Zuazo was? No. Let's talk a little bit about leaving town. This Mrs. Diaz, the mother, Danielle, testifying yesterday, she doesn't really know when they left. They were going to leave. They were always going to be leaving. But, all of a sudden they were going to be leaving maybe that day. She was asleep because she works these long hours. So she doesn't want to give you too much information. She surely wasn't, I would say, a cooperative witness. I wouldn't tell you that she lied absolutely, but I wouldn't put a lot of faith in what she had to say. But I got thinking about the newlyweds, and what I didn't hear about from either one of them, even though they have this desire to have their own house, is that either one of them had a job. We got some text messages about being behind on the rent by 5 days on the house down in Texas, or the apartment, or whatever kind of a residence it is. And then, the response is, yeah, well, we spent all that money in PR, which I imagine is Puerto Rico, but I don't really know. Probably the honeymoon. And so, no job, no means of getting the dream house or even putting food on the table. What's going on here with Mr. Zuazo? Where is he when he gets arrested? Monday morning, October the 14th, or maybe it's the afternoon, but sometime on that day when the fugitive apprehension team comes to the job site where he's working. He didn't leave town. He didn't go anywhere. He's here, easy to find. The only reason they find him is because of this Kelly Broad coming in with his chip on his shoulder to identify him and say, well, I think this is the guy. Getting even for whatever it was that he's not happy about. But Mr. Zuazo's not down in Cato Parish, Louisiana, heading to Texas. He's not getting on a plane to fly to Europe or something like that. He didn't go anywhere. Well, now why would he just be sticking around while Hernandez has gotten out before the day is over? He's on the road heading home because he doesn't have a guilty conscience. He didn't do anything. He's got nothing to run from. Let's go back to Lowe's. 9:30 in the morning. You have this video. Maybe it's Mr. Zuazo in there. That's going to be for you to decide. Let's say, for argument's sake, that it was him. That doesn't prove that he went anywhere beyond that place where that store where Mr. Hernandez made the purchases or paid for whatever it was he got. And what do you see with Zuazo? What's he got? Bottle of pop. Look at those videos. Or a bottle of something. I can't tell you it's pop. Look at those two receipts, the one from Lowe's, the one from Home Depot. There's some sort of drink in both of them. There isn't any question that these men know each other. The question is, were they there together that day at the Murray house? Are they both responsible? And certainly Hernandez was. But is Mr. Zuazo with them then? Not at 9:30. There's no crime committed at 9:30 in the morning down in Allen Park. Is he responsible for the wrongdoing in which Mr. Hernandez was engaged at 11:30 to noon later that same day, the 14th day of October? That's the question. That is the key question of fact in this case. Now, in the instructions you're going to receive, you've heard this once before, and you'll hear it one more time by Judge Polis when she gives her final instructions. But it's the instruction about presumption of innocence, burden of proof, and reasonable doubt. And I ask you to keep this in mind because she's going to say this to you. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. And then it goes on to say a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. A doubt that is reasonable after a careful consideration and careful and considered examination of the facts and circumstances of the case. This is essential to making a determination of the truth here. You have to be firmly convinced that Mr. Zuazo is guilty of any one of these three crimes, because the same standard applies to each crime charged, and you have to consider each crime charged individually. But no matter which one you're deliberating upon at a given time during those deliberations or discussing, think about that. You have to be firmly convinced that he's guilty beyond a reasonable doubt. We haven't seen that level of proof. Firmly convinced. There's a big question here raised about identification. And I told you in the beginning that this would be the key to the defense presented. They have the right guy. And when she instructs you on this particular point of law, Judge Polis is going to say, among other things, in deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. So, in the case of Mrs. Murray, this has particular relevance because her state of mind at the time would be one of terror. Whose state of mind wouldn't be that way? She had interactions with the police. They were back to see her multiple times. She's the only eyewitness. So she's a very important person, and I think it would be very difficult if I was a detective investigating this case to have to bringing up this wound with Mrs. Murray so soon after it happened and asking for more details. But they have nowhere else to go to get this information. And in the back and forth, the trading information, she comes to have an understanding of who it is that the other suspect is. And so she's able, without question, you know, when she testified here very clearly, she's able to use names. She knows who the defendants are, without question. And she can certainly identify Hernandez. But I submit to you that she has adopted an understanding that Mr. Zuazo, because he is the defendant, is actually the person who was there in her house. She's testifying honestly. She's simply mistaken. And I think that that is a common enough thing that can happen to a person who's a victim of a crime. And even if she wasn't a victim herself, although she was or is, for the unlawful imprisonment perpetrated by Hernandez, who tied her up with duct tape, she's got all that trauma to deal with. So that could have an effect on her ability to recount the events completely accurately and to be able to identify Mr. Zuazo. Now, there's something about blood on the sleeve of the person, the second person, but we don't have that in evidence. So we don't know whatever happened to that sleeve, the shirt it was on. It's just not before you. It's something that was seen. And there's another thing, there's some blood on a wall upstairs, a blood mark. I didn't hear any evidence about any DNA being taken from that stain on the wall. So while one might, under circumstantial evidence, because you'll get an instruction on that as well, be able to say, well, you know, this is a blood mark up there, and there's this horrible thing that happened, and maybe that blood is Mr. Murray's blood. And maybe it is, and maybe something happened where some accident occurred and there was some blood that ended up on a wall that didn't get cleaned up immediately. I mean, I know there's been things in my own home that have gotten messed up that didn't get cleaned up immediately. Sometimes you don't notice something, and it's quite another when the police investigators, I think that Ms. Myra testified to like 15 people being there on the afternoon and into the evening of the 14th of October last year. They're going to see everything. They're looking everywhere. But how long that was there, we don't have any testimony to that. We certainly didn't hear Ms. Murray say, well, you know what, I never had anything like that there before. It wasn't there that day. That wasn't the testimony. At least it wasn't touched upon. Reasonable doubt? Whoever went upstairs did ransack the place. It's all terrible. It's a horrible tragedy. I, even though I'm an advocate for Mr. Zuazo, because I'm not a juror, can at least allow myself to have compassion or sympathy for Mrs. Murray. You all can't do that while you're deliberating and thinking about what the facts are. You have to use what I told you about in opening statement, or my opening statement, is that cold-eyed calculation to come to a determination of what the truth is. I know that's what you're going to do when you deliberate. I appreciate all the attention that you've paid to me here this afternoon, all the time, that you have, all the attention you paid during the course of what is now the fourth day of our trial, all 4 days. I've done everything that I can do for Joshua Zuazo. I'm going to sit down in a minute. And Mr. Pietrofesa is going to get up and attempt to poke holes in what I've just told you here this afternoon, because that's the way the system works. And he gets to talk twice and I only get to talk once because he has the burden of proof. And so he gets the opportunity to give a rebuttal argument. And that's the way the rules work, and that's perfectly fine. I'm confident in that burden of proof business, and I am very confident in proof beyond a reasonable doubt that you will find that Mr. Zuazo, that hasn't been proved against him, and that he would be found not guilty. But when Mr. Pietrofesa makes his points, I ask you to keep in mind those things that you anticipate after I've talked so long that I would have said, given an opportunity to get up again, which I won't have. And as I told you a moment ago, I've done everything that I can do for Joshua Zuazo. And now I leave him with you and in your capable hands. Thank you. Thank you, Your Honor.
You're welcome.
My goal now is to stop talking about 60 seconds before everyone stops listening. You've heard a lot. It's been very intense. The closing arguments have been long and also intense. So let me start by saying, in a response that wasn't how I was planning to say it. Mr. McCarthy, I've known for a long time. He's an excellent attorney. He's an ethical attorney. He would never intentionally mislead you from something that has occurred during the trial. A lot of stuff happened yesterday. A lot of DNA evidence came in, and I believe Mr. McCarthy misspoke just now in his closing. Mr. McCarthy said that blood swipe upstairs was never DNA tested. It was DNA tested. That was in the lab test number 5 that we had testimony about yesterday. It's exhibit number 8E. It's the upstairs wall swipe, and it comes back to the victim, Sam. You have the report, and that's enough. And I don't believe, and the same thing, if I misspeak on something, it's not intentional. I know Mr. McCarthy's wasn't intentional, but what he said wasn't correct. That was tested. Now, a couple other things that he mentioned was about missing evidence. Well, you know what the defendants did as soon as they left the residence that day. That was to go destroy evidence. So I don't know what was burnt up in the vehicle, but they attempted to burn up the vehicle, destroy DNA evidence. You know, a lot of things weren't recovered that were taken. Cell phones weren't recovered. The pistol wasn't recovered. The cash wasn't recovered. And Mr. Hernandez left town immediately because he had someplace else to go. This defendant was still here, but he had several days knowing what was going on, knowing what was in the paper and on the media to get rid of any evidence that he may still have had, so it wouldn't be at his residence when the sheriff's office showed up. So it's not surprising that there wasn't any additional evidence that was found there at the house. Now, there's certain things that, when we talk about Mrs. Murray, when we talk about the witnesses, that it's beyond common sense, it's beyond reason when you're looking at things. It's impossible. Just certain things about this identification of this defendant would be impossible to have happen if it wasn't accurate. I don't have to prove impossibility, beyond impossibility, but it's actually impossible in my estimation regarding Mrs. Murray's identification. She says, square away, I saw his face when the mask dropped. She says that. She identifies the defendant. She identifies him under oath, back in December of last year, says, I recognize him from the house. Okay? Now, what's impossible about that identification if it's a misidentification? Well, what's impossible about that misidentification, when she says it a year ago, when she says it under oath, what's impossible for Mrs. Murray to know? It's impossible for Mrs. Murray to know that the defendant's DNA is going to be found in the basement of her house. That's impossible. And if you notice, the one thing we didn't hear, although we had opportunity to discuss anything, was anything about the defendant's DNA on that duct tape. Two sets of duct tape in the basement of that house. That wasn't discussed. That's identification. What else is impossible? Well, when Mrs. Murray is making that identification, she doesn't know if there's a connection between Hernandez and him. She doesn't know that they go back. She doesn't know that there's all these text messages. What if the investigation went back and it wasn't that? What if the investigation went back and it was somebody else's DNA in the basement to discredit that identification? No. Everything that goes forward says this is the right guy. And what else you have that can't be created? Mrs. Murray doesn't know that Ms. Diaz is going to know the defendant, that she's going to know the defendant and his connection with Hernandez. It's impossible for that connection to have been known by Mrs. Murray when she made her identification. It's impossible. And what else is impossible is that Mr. Broad, when he testifies, he says, yes, I also know him by Yogi. Impossible for him to know that Mrs. Diaz, who's also going to identify him, knows him as Yogi. It's going to be impossible that he knows the connection with Hernandez. Hernandez is the obvious guy on the video. But he doesn't know that. He never has talked about Hernandez. But he knows the defendant. It's the rest of the investigation that brings everything together, that all these are connected to the defendant. It was also said at one point that on October 11th at 9:30 he hadn't done anything wrong. You've seen the planning that had gone through this case way before the 11th. You had seen the planning that this defendant did to get the DTE items, to get the helmet, to get everything else that was needed to be impersonating DTE officers to get into that house. So we're supposed to believe that somehow he does all this preparation work, that somehow he's identified by all these witnesses, but somehow there was somebody else who was there with Hernandez on the night of the 10th, and then suddenly that person disappears and he's the one who goes with him to Lowe's, and then suddenly he disappears again. That's not reasonable, and that's not what the facts are. I'm going to end it here, but I believe when you go back, you're going to conclude this is the other person who was there, as the testimony, the DNA has said, and that the defendant is guilty as charged on all counts. Thank you.
Okay, thank you. Members of the jury, the evidence and arguments in this case are finished. I'm going to now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You should take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide this case. A person accused of a crime is presumed to be innocent. You must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made of parts called elements. The prosecutor must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide this case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only sworn testimony of witnesses, exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'm going to describe some of the things that are not evidence. The fact that a defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements, arguments, and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law, and I tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case only from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that was let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge that you have about a place, person, or an event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witness you believe and how important you think that their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice that you may have based on a witness's disability, race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you might need to test what might be an automatic or instinctive judgments and reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it might help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How did the witness look and act while they were testifying? Does that witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? And all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case. Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about what testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide this case. And if so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things and told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 11, 2024 in Oakland County, Michigan. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. But facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that's circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. When the lawyers agree on statements of facts, those are called stipulated facts, and you may regard such stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. And you've heard testimony from witnesses who have given you their opinion as experts. Experts are allowed to give opinions in court about matters that they are experts on. However, you don't have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts that they give for their opinion and whether those facts are true. You should only think about the expert's qualifications and whether their opinion makes sense when you think about all the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. As to count one, the defendant is charged with a crime of first-degree felony murder. To prove this charge, the prosecutor must prove the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to cause great bodily harm to Hussein Murray, or he knowingly created a very high risk of death, or great bodily harm, knowing that death or harm or such harm would be the likely result of his actions. Third, that when the defendant did the act that caused the death of Hussein Murray, the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. For the crime of larceny, the prosecutor must prove the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that there was some movement of the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises. Fourth, at the time the property was taken, the defendant intended to permanently deprive the owner of that property. The defendant must have been either committing or helping someone else commit the crime of larceny. To help means to perform acts or give encouragement before or during the commission of the crime that aids or assists in its commission. At the time of giving aid or encouragement, the defendant must have intended the commission of the larceny. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant or someone who aided and abetted caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, that the defendant or someone that he aided and abetted had one of the three states of mind. He intended to kill, or he intended to do great bodily harm to Hussein Murray, or he knowingly created a very high risk of death or great bodily harm, knowing that such death or such harm would be the likely result of his actions. Third, that the killing was not justified, excused, or done under any other circumstances that reduced it to a lesser crime. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. As to count 2, the defendant is charged with a crime of unlawful imprisonment. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant knowingly restrained Hussein Murray. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, that the defendant did so under one or more of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret, or the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. As to count 3, the defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant knowingly restrained Linda Murray. Restrain means to forcibly restrict a person's movement or to forcibly confine the person so as to interfere with that person's liberty without the person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, that the defendant did so under one of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret, or the person was restrained to facilitate the commission of another felony, or to facilitate flight after commission of another felony. One of the issues in this case is the identification of the defendant as the person who committed the crime. The prosecutor must prove beyond a reasonable doubt that this crime was committed and the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good of a chance the witness had to see the offender at the time. How long was the witness watching? Whether the witness had seen or known the offender before. How far away what the witness was. Whether the area was well lighted and whether the witness's state of, and what was the witness's state of mind at the time. Also think about circumstances at the time of the identification, such as how much time had passed since the crime. How sure the witness was about the identification, and the witness's state of mind during that identification. You may also consider any times that the witness failed to identify the defendant or made an identification or gave a description that did not agree with the identification of the defendant during this trial. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict the defendant as long as you believe the testimony and if you find that it proves beyond a reasonable doubt the defendant was the person who committed the crime. In this case, the defendant is charged with committing first-degree felony murder and 2 counts of unlawful imprisonment or intentionally assisting someone else in committing it. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, that the alleged crime was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of that crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at the time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or the crime alleged was a natural and probable consequence of the commission of the crime intended. It does not matter how much help, advice, or encouragement the defendant gave. However, you must decide whether the defendant intended to help another commit the crime and whether his help, advice, or encouragement actually did help, advise, or encourage the crime. Even if the defendant knew that the alleged crime was planned or being committed, the mere fact that he was present when it was committed is not enough to prove that he assisted in committing it. When you go to the jury room, you're going to be provided a copy of these written final instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has had a fair chance to be heard. During your deliberations, please turn off cell phones or other communication until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agree on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk with each other and make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding a lesser offense. As to any count which includes a lesser offense, you first consider the principal offense. If you agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe the defendant is not guilty of the principal offense, or if you can't agree on that offense, you then may consider the lesser offense. It's up to you to decide how long you consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want to. If you have questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you're going to submit them in writing in a sealed envelope to the court clerk. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court clerk. It's not proper for you to talk to me, the lawyers, court officers, or anyone else involved in this case. And as you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and these full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. As I said, you are going to get a copy of these written instructions that you just heard, and you should think about all my instructions together as the law you are to follow. Is there any objection to just giving the jurors exhibits if they ask for them without reconvening?
No, Judge.
There's none by the defense.
Okay, thank you. All right, so the defendant is charged with 3 counts. That is, with the crimes of first-degree felony murder and 2 counts of unlawful imprisonment. These are all separate crimes, and the prosecutor charging the defendant committed all of them. You must consider each crime separately in light of all the evidence in this case. You may find the defendant guilty of each or any one or any combination of these crimes, guilty of a lesser serious crime or not guilty. A verdict form is prepared and will be sent back with you. All right, so just some logistical things I want to talk to you about. So from this point on, when you go back, I do not manage your time back there in the jury room. If you want to take a break outside of your jury room, you're gonna write a note. I would first go back and pick a four-person, choose a four-person, and then moving forward, a note should be written to court staff to let me know when you're gonna take a break. So, if you're gonna take a break amongst yourself in your jury room, I don't need to know that. But if you want to leave your actual jury room and go get a cup of coffee, what have you, take a walk, whatever it is, you have to let us know. And you are gonna write that in a note. You're not gonna be able to immediately leave. When you write that note, the note is then brought to my office. I read it, and then I will say whether or not it's an acceptable time to take a break. So don't leave your jury room unless you're told you can. But I tell you all of that to say, you can decide that you need a break right away, or you can decide you need a break whenever, all right? So I'm not gonna manage your time moving forward. You're gonna get a buzzer if you haven't already gotten one when you're back there. And anytime you wanna have any conversations with the court or ask for a break or have any questions regarding any evidence, etc., you're gonna use that buzzer. A member of court staff will come over to your jury deliberation room. They're gonna knock really loud and say, stop deliberating. So you are to stop deliberating because they do not wanna be a part of that deliberation. You come in, you hand them a manila envelope that will have your note. That note is then brought to me. They can't answer any questions for you, okay? If the note now is anything outside of, I need a break, or I want the evidence, which the lawyers just said they were okay with, sending back to you without reconvening. Anything else that is written on that piece of paper requires all of the parties to come back into court, and it is read into the record, and the lawyers offer their opinions as to how it should be answered. You're then brought back in the courtroom, and that answer is given to you. Why do I tell you that? Because we obviously have two juries, and sometimes, even when we have one, that answer is not immediately able to be given. Do not feel like the court is not answering your question. I didn't go home, I didn't fall asleep, I promise you, I'm getting you that answer, and I'm working to get you back here to get it. Another question that I typically get from jurors is, I didn't see this in the evidence, but may recall from the testimony or maybe in your notes that someone referred to a document, one of the lawyers referred to a document, or maybe lifted something up. If that is not in evidence, it is not coming back to you. And I'm telling you that because it's not because we forgot to give it to you. If you still have a question about that evidence, go ahead and ask for it. But don't be concerned that something in that evidence package isn't sent back to you. Also, there's digital evidence in this case. I am not going to provide you immediately an electronic device for you to be able to view that. If you want an electronic device to view the digital evidence, you are going to have to ask for that, either in that same note or in a separate note. Okay? All right, so I think I've answered most questions, and obviously at this point we have 13 of you. So we are going to draw lots to determine which one of you will be excused as an alternate. Generally speaking, an alternate is not typically called back, in all honesty. But in a case like this, I'm unsure how long the deliberations are going to go on for, and it could be very likely that you could come back. So if you're an alternate, all of those restrictions that I had given to you early on are still going to apply, even if you're allowed to leave for the rest of the day. Know that the moment I get a verdict from your jury peers, a member of court staff will call you immediately to let you know a verdict has been reached. And if you'd like to know what that verdict is, they'll provide that information to you. And it's my understanding that we already have everybody's phone number. So if you're excused, you're going to be able to leave at this point, or you may stay. It is completely up to you. The restriction regarding talking to media, if you're an alternate, remains until you hear that you are not required to come back. All right, we're going to draw lots and see which one of you will be
Judge,
excused.
you can approach first before you do that for 5 seconds.
So it's basically going to be titled People of the State of Michigan versus Joshua Zuazo. The verdict form is going to say you may return only one verdict on each count, mark only one box at each count on the sheet. Count 1 is going to list first-degree felony murder. There's a box to check not guilty. There's a box to check guilty as charged of first-degree felony murder. And then there's a third box under that count that says guilty of the lesser offense of second-degree murder. Count 2 says unlawful imprisonment. There's a box that says not guilty. and then there's a box right under it says guilty as charged of unlawful imprisonment. Count 3 is unlawful imprisonment. There's a box that says not guilty, and the box right under it says guilty as charged under unlawful imprisonment. When you fill this form out, that is what you want to leave with you in your jury room. Your foreperson signs it and dates it. When you let me know that you got a verdict, you just write a note to say, we have reached a verdict. And then you are brought out here with that folder, and that's how we take your verdict. Okay? Satisfied?
Yes, yes, sir.
Okay, all right, let's pick a lot to see who is going to be seats.
Juror number 14.
All right, so that is you, juror seat 14. You know what, I'm going to have you, and when I excuse everyone, then we'll just have somebody take you down the hall. At this point, I am going to go ahead and swear in my clerks. Please raise your right hand. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise, that you will not communicate with them or any of them orally or otherwise except by order of this court, or to ask them if they have agreed upon their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I will.
All right, thank you. All right, ladies and gentlemen.
All rise for the jury, please.
Any objection to the form and manner of the reading of the verdict of the jury instructions?
No, Your Honor.
No, Your Honor.
Okay, all right, so then we will get that door closed. And Mr. Zuazo can go down, and if I hear from the jury, I will let you know, Mr. McCarthy, and we'll bring him right
nearby.
up. Yes,
I'll
you'll be
leave my
nearby.
number
Okay, great.
there.
And
Yeah.
do you want about 20 minutes?
No.
You want to get right into it?
Yes.
All right, so then let's get Mr. Zuazo down. We'll get Mr. Hernandez up.
Thank you, Judge. And just so your clerks know, we
You
can
know
fix
what,
it.
I didn't tell them about the,
Yeah.
and they can't just open
We'll-
those back.
we'll
Why don't we
We'll deal with it as soon as.
Why don't we get through your
Yes.
closing, and then when I get the evidence, we are gonna reconvene for that, so then I can explain to them that they can't just, if they do go through the packages, they are gonna need gloves and also.
It's, yeah, the photographs we should be able to do. I think we should have everything ready. I don't think you need to bring them back to discuss that until they have a question. We should get that for you. Once the attorneys are talking,
No, my concern is, are you sending back the physical items of
not
evidence?
unless they ask for it, no.
We'll see, but I didn't clarify that for them, so I will bring them back to clarify that.
Okay.
Okay, all right, I'll be right back.
All rise.